Hey guys, Attorney Marc Victor here. I am the owner and founder of the Attorneys for Freedom law firm. Today, I want to talk about the CCW Safe, and I've got their contract right here. So I want to give you my opinions just from reading through, poking around a little bit through the CCW Safe program. And by the way, if you're interested in the US Law Shield program, we're going to do that one very soon, so stand by. For starters, on page 3, right up at the top of the contract, CCW Safe provides no services or coverage in Washington or New Jersey. So if you're in Washington or New Jersey, forget it. You're not eligible for the CCW Safe program. Also, there are restrictions for New York. Seems to me that if you are a law enforcement officer, maybe you can sign up for CCW Safe. But otherwise, I think if you're in New York, it's not an option for you to join this program. Okay, no big deal if you're in one of the other states. But then I get to the bottom of page 3. Member services apply only to a recognized self-defense use of force incident that. First I note, here's that language again. It's got to be a recognized self-defense use of force incident. Recognized by who is my question. It has to occur at a location where the covered member may legally possess firearms. Well, there are lots of places that you can't legally possess firearms, right? I mean, think of government buildings, think of schools, think of the courthouse, think of businesses, right? Lots of businesses say no guns allowed. It certainly seems if you're at one of those places and a self-defense or a recognized self-defense use of force incident occurs there, no coverage whatsoever. But remember, since the Bruin case, there's lots of litigation going on now about what's a sensitive place. That's important because under Bruin, if it's a sensitive place, well, you may not have a right to carry concealed in that place. And as you know, many states now are effectively trying to make their whole state a sensitive place, right? They want parks and public transportation and this, that, and the other thing. And some of them are even proposing things like all businesses are sensitive places where you can't carry a firearm unless the business specifically puts a sign up and says you can. So I don't know how that's going to shake out because at the time of this recording, all of this litigation is still pending. But if the anti-gun crowd gets their way, lots and lots of places will be illegal to carry a firearm. If your recognized self-defense use of force incident occurs on one of those places, no coverage whatsoever under CCW Safe. No problem, by the way, with the Attorneys on Retainer program. Okay, so now I turn to page 14. Page 14 at the bottom, you can see lots of notes and lots of stuff highlighted here. Restrictions, limitations, notices, and exclusions. And then, of course, you see criminal acts. Criminal acts are excluded. Why did you buy this thing in the first place? Because if you're charged with a crime, this is the thing you care about. But anyways, let's keep going. Some fancy language in here. CCW Safe will not provide the services if the use of force incident is an intentional criminal act, i.e. robbery. And then very importantly, there's an or where there is no admissible evidence of self-defense, period. Well, so the way I read that is CCW Safe will not provide the services if the use of force incident is an intentional criminal act, i.e. robbery, even if there is admissible evidence of self-defense. I mean, that's my opinion of what that means. Well, what type of use of force incidents are intentional acts? Now, they give robbery as an example, but of course, robbery is not the kind of charge where you're going to likely be making a self-defense type of an argument, but it is an intentional crime. What else are intentional crimes? Think murder. What if you get charged with murder? Does this mean that if you're charged with murder, that CCW Safe can say, sorry, no coverage whatsoever because it's an intentional act, period? What else? Well, assault, and specifically aggravated assault, right? Say you shoot somebody with your firearm and you are charged with aggravated assault. That's definitely an intentional act, or at least most of the time an aggravated assault will be an intentional act. It appears to me from this reading that's not covered. Also, all attempt crimes, right? What if you're charged with a shooting, you think it was self-defense, somebody didn't die, but you get charged with attempted murder? That's certainly an intentional crime, certainly an intentional act. It seems to me, under this wording, that CCW Safe is not going to give you any coverage. Now, I don't know how they're going to interpret it, but that's my opinion of what this means. But then there's the or. Now, if it said and, I would feel differently about it, right? Because and, where there is no admissible evidence of self-defense, that seems fair and reasonable to me. Because if there's absolutely no admissible evidence of self-defense, which is very difficult to imagine, right? Because your testimony as the defendant in a criminal case, and nobody can keep you off the stand, you have a right to testify and say, I acted in self-defense. That's admissible evidence of self-defense. That is your statement about what happened that you have a constitutional right to testify at trial about. So that language doesn't really make sense. But then, or where there is no admissible evidence of self-defense, seems a little strange to put that in there. But then it goes on. CCW Safe will not provide the services of a firearms response if in a place where it is a misdemeanor or felony to possess a firearm. Okay, so we already talked about that. It's got to be at the right place. And then this leaves me with, obviously, the things I've already discussed: schools, courthouse, businesses, sensitive places. But what about the question of crimes that are not intentional, manslaughter crimes, disorderly crimes? So to sum up this section on page 14 at the bottom, there seems to be very clearly saying that if the use of force incident is an intentional act, like a robbery, and we can certainly add other intentional acts in there, the murder, the assault, the aggravated assault, the attempt crime, seems to me, in my opinion, that this is not a covered event. Okay, but this still leaves on the table the unintentional types of discharges, maybe a manslaughter, which is generally a reckless shooting, or an involuntary manslaughter, think negligent homicide, this will be negligence or gross negligence, or maybe even a disorderly conduct, which is a reckless crime. Okay, so those are still potentially on the table as things that would be covered under the CCW plan. Okay, so moving right along to page 15. One of my favorite sections right here that I think you should read if you're thinking about CCW Safe. Selection of counsel. Did you think you had a right to select your own lawyer if you got CCW Safe? Read the contract. Again, this isn't my opinion here. This is reading from their own section. It starts with, if, in response to a recognized self-defense use of force incident, CCW Safe provides services which include the selection and retention of counsel to represent a covered member. Hold on, did I say if? What do you mean if in response to a recognized self-defense use of force incident? I thought you were definitely covered if it was a recognized self-defense use of force incident. That if there gives me concerns. What do you mean? You might not cover it even if it's a recognized self-defense use of force incident? The language then goes on to say, the covered member expressly and unconditionally acknowledges that CCW Safe possesses the exclusive and ultimate authority to select counsel, retain counsel, manage litigation subject to the applicable rules of professional conduct, select expert witnesses and other litigation support services, and retain expert witnesses and other litigation support services. But don't worry, you have some rights here. It goes on to explain, although a covered member may recommend or suggest counsel, a covered member expressly and unconditionally acknowledges the aforementioned exclusive and ultimate authority of CCW Safe. Okay, that seems pretty clear. You don't get to pick your counsel, period. They're picking your lawyer for you. You may recommend or suggest counsel, but they have the absolute, or as they say, exclusive and ultimate authority, unconditionally acknowledged by you, that they get to select your lawyer. So if you think you get to select your lawyer with CCW Safe, you don't. That seems very clear from their language. That's something you might want to consider with CCW Safe. Now, with the Attorneys on Retainer program, you know who your lawyer is. It's the Attorneys for Freedom law firm. Moving on to the very next paragraph, cooperation. Again, one of my favorites. At all times, covered member must cooperate with CCW Safe in connection with any services provided to covered member, including but not limited to. There's a whole laundry list of stuff. On that laundry list, it says, and I'm quoting from the cooperation paragraph on page 15, in authorizing any attorney assigned to assist covered member to communicate with CCW Safe regarding the information reasonably requested by CCW Safe. Covered member must execute any consent to release information as required by any attorney assisting covered member pursuant to plan benefits. Huh? You mean you got to sign a statement, and of course you're going to have to sign a statement because any lawyer is going to say, I'm not going to talk to CCW Safe. Why would they say that? Because they're waiving attorney-client privilege. Anything your attorney is going to tell CCW Safe is going to be discoverable. So they're going to say, sorry, I'm not going to tell CCW Safe or anybody else anything about our communications. That's called attorney-client privilege and the duty of confidentiality, and we're not going to waive that. Under this plan, you must execute any consent to release information. You're waiving attorney-client privilege. Why would they want this in their plan? Because it's my opinion. They want to talk to your attorney to determine whether or not they can deny coverage here. That's my opinion. It doesn't say that in the contract, but it certainly seems reasonable to me. Why else would CCW Safe require that you sign authorization that your lawyer who's representing you in a criminal offense has to talk to CCW Safe? The prosecutor finds out about this, guess who they're going to interview? The person at CCW Safe. Guess what their question is going to be? Tell us everything that your lawyer told you, meaning your lawyer, the covered person, the person who's charged with the crime. CCW Safe, tell us everything that lawyer told you about the case. What kind of defenses are you going to bring? What did the defendant tell you, by the way? What are the problems with the case? All of these other things. Do you really want to sign this? This to me seems like a massive problem. Look, these kinds of problems arise because CCW Safe isn't a law firm, right? That's part of the problem here. They're all trying to get around the very serious problems with not dealing directly with the lawyer. Okay, moving right along, next paragraph. Unintentional discharge. This is an interesting paragraph too. CCW Safe will not provide the services if the incident is unintentional and considered an unintentional discharge. Okay, what's an unintentional discharge exactly? Well, they tell you it includes, maybe not limited to, but it includes the unintentional use of any other legal weapon or force. So, of course, the accidental discharge, that's not covered, right? In our opinion, in our experience, this is probably the most likely problem you're going to have if you're a responsible gun owner. The oops, an unintentional or accidental or negligent discharge of a firearm. That's a pretty serious crime in most places, absolutely not covered with CCW Safe, absolutely covered with the Attorneys on Retainer program. Probably the most likely situation you're going to actually use the coverage, not covered there. But what else is read into this? Well, in my opinion, if they're saying this includes the unintentional use of any other legal weapon or force, does this mean that negligent homicide or involuntary manslaughter is not covered as well? Well, we got to look at the definition. What is an unintentional discharge? Well, if you go to page 23 of the contract, you'll find a definition for an unintentional discharge. It means the firing of a firearm at a time when the covered member does not intend to fire. Okay, that's your negligent discharge. But this includes accidental and negligent discharges. They're telling you right now, a negligent discharge is not covered. Does that mean a negligent homicide? Does that mean an involuntary manslaughter? Does that mean a manslaughter? We already know the intentional crimes from what I read earlier. Now, they used robbery, but it certainly seems reasonable to conclude that this is going to include murder and aggravated assault and attempt crimes. Those are out. Is the manslaughter and the involuntary manslaughter and the negligent homicide out as well? I don't know. I'm just giving you my opinion about this contract, but it certainly seems very reasonable that CCW Safe could, if they wanted to, deny coverage for virtually anything you want to use it for based on this wording of their contract. Okay, I leave that to you to decide on your own. Again, I'm just reading from their contract, something you should probably do if you're considering signing up or if you're already a member of CCW Safe and you haven't read the contract yet. Moving right along. Substances that alter judgment. CCW Safe will not provide the service if, at the time of the use of force incident, you are impaired in public or private property not your own by the use of alcohol, controlled substances, or prescribed medication that impairs judgment. Okay, so it seems to me pretty clear that if you are impaired at all by alcohol, drugs, legal or illegal, or prescription, they're not going to give you coverage at all. Well, this happens sometimes, right? You might be out, you might be at a bar, you might be enjoying an evening, you might be having a glass of wine with your dinner. Sorry, seems like they can deny coverage here. But they leave the possibility of you being at home and impaired. Maybe you're still covered there. But then there's an or in any location, which seems to me to include your home, you are in violation of state law or regulation concerning alcohol and drug use while in the possession of a firearm. Well, it seems to me lots of places say, no, you can't possess a firearm if you're drinking alcohol. Does this mean that even in your home, if you're drinking alcohol, no coverage for you? Certainly my opinion, they can deny coverage based on that in your home. So if you're drinking alcohol, sorry, you at least have an issue with the CCW Safe contract. Moving right along to the next section, page 16, domestic relationships. I'm happy to see domestic violence cases are covered under the CCW Safe. I want to be fair with them. Lots of other companies just absolutely exclude domestic violence type cases. This is a hot topic because lots of these types of conflicts can happen in the home, especially with people who are exes, ex-wife, ex-girlfriend, or boyfriend. These types of incidents come up. They are covered, but then there's this hugely important exception. The very last sentence of the domestic relationships paragraph. I'm going to read it verbatim. You can draw your own conclusions. CCW Safe does not cover incidents that are the result of a criminal act by the member or illegal activity. Huh? Isn't that why you're buying this thing? If you get charged with a crime or you commit an illegal act, not every use of force incident that you think is going to be perfect self-defense is going to be agreed to by the prosecutor. In fact, that's why you're charged, right? The prosecutor doesn't think that you acted in self-defense, or the grand jury doesn't think that you acted in self-defense. They might think that this is the result of a criminal act or illegal activity. In fact, they do think that that's why you're charged with a crime. Now, again, I'm just reading their contract. It's certainly my opinion that CCW Safe can deny coverage as a result of this provision. Okay, so now this other section, invalid permits and disqualification. CCW Safe will not provide permit plan services if the member no longer holds a valid carry permit, fails to be eligible to carry a weapon without a permit, fails to meet the legal requirements of LEOSA, fails to provide and maintain accurate and truthful information on their CCW Safe member profile, becomes subject to a condition which would preclude or disqualify him or her from holding a valid concealed carry weapons permit, or are otherwise no longer in good standing with CCW Safe. Okay, there's a lot packed into this. Hard to know exactly how CCW or a court would interpret this section, but imagine you have a permit and you're in a state where you need a permit and your permit expires and now you can't even have a firearm. Or you need a permit to go outside and your permit expires or is invalid. You go outside, you defend yourself, self-defense case. Certainly seems to me CCW Safe may very well not cover that incident as a result of this paragraph. Hard to know exactly whether they would cover this or not. With attorneys on retainer, you don't have to worry about that stuff. You get charged with a crime, we can bring the defense of self-defense. The crime happened after you signed up. We're going to defend you. All of these exclusions don't apply. We don't get so tied up in whether your permit is valid or not. What we care is, can our lawyers ethically bring a self-defense claim? If they can, we'll defend you. Page 17, outside scope of coverage. CCW Safe will not provide subscription benefits for any incident or event that is not a recognized use of force self-defense incident, which includes, but not limited to, an arrest or administrative action that does not follow a recognized use of force self-defense incident. Okay, who gets to decide this? It says at the end, the last paragraph here, no funding, legal or company resources shall be provided for any incident outside the scope of coverage. All right, it's got to be a recognized use of force self-defense incident and still clear all of the other hurdles that we have talked about in order for there to be coverage. It certainly seems like there are lots of places, if they want to deny coverage here. Again, I don't know how they're going to interpret their own contract. I don't know how a court would interpret this contract. I'm simply giving you my opinion. But if we get to page 24, we finally find out what on earth is a recognized self-defense use of force incident. This is in the definition section. We know here from reading this, well, first let me read it for you in case you don't have the contract in front of you. Recognized self-defense use of force incident means an incident where force is used pursuant to a reasonable belief that use of deadly force is necessary to protect from imminent danger of death or great bodily harm, period. This includes any necessary force with all legal weapons and physical force to defend against a life-threatening attack in self-defense. Okay, so I think we could probably summarize that by saying there's no coverage unless you are under a fear of death or great bodily harm. Well, so we can exclude immediately all uses of self-defense that are ordinary uses of self-defense, right? Somebody's going to punch you in the face. Maybe you pull out your firearm and say, hey, don't do that. I got a gun. You get charged with something. You weren't under a fear of death or great bodily harm. So it certainly seems like this is not a recognized self-defense use of force incident. But again, it says used pursuant to a reasonable belief. Whose reasonable belief? The prosecutors? The grand juries? Yours? Someone over at CCW Safe who's deciding whether or not you acted reasonably? All this is not something I can answer for you. But it seems very clear that if CCW Safe wants to deny coverage, it seems like there are lots of opportunities for them to deny coverage. And what's the reason for this? Look, CCW Safe may not be an insurance company themselves. That's fine. They very likely are using an insurance company. And the facts of reality in the United States are you can't insure against an intentional tort or a criminal act. And so there's a lot of dancing around to say we don't cover these types of things. But if you read this contract and read it for yourself, again, everything I've said here is just my opinion and my interpretation. I don't know how a court would find this would mean. I don't know how CCW Safe is going to interpret it. But if they're going to cover you, they should say that. All right, some people have said, hey, Mark, I called CCW Safe and asked them if I get charged with a crime, will you cover me? And they told me yes. Okay, look, I can't speak to that. Anybody on the phone can tell you anything they want over the phone. What I'm speaking to is what's most important. What's in their terms of service? What's in their contract? What I read to you is what's in the contract. If they say they're going to cover you if you're charged with a criminal act, ask them to put that in the contract. Make it clear. They're going to cover you if you're charged with a crime. Now, don't settle for some dude on the phone who said, oh, yeah, man, no problem. We'll cover it. Look at the contract. Read it for yourself. Make your own informed decision. Take a look at the attorneys on retainer contract. It's online. You can look at it. Unless we cannot bring self-defense, which means we'd be engaged in an ethical violation by bringing a frivolous claim of self-defense. What kind of case is that? Okay, probably the robbery that CCW Safe brings up. If you barged into a bank, pulled out a gun, stuck in a teller's face, said your money or your life, and now you're charged with a robbery, okay, that's not going to be a self-defense case. No program is going to cover you on that. But if you say it's self-defense and we can bring that argument, none of these other exclusions matter to us. As long as you were a member of the program and we can bring self-defense and the incident occurred, it arose after you signed up in attorneys on retainer, none of these problems. We're not going to disclose anything we learn about the representation to anyone else. We're not going to exclude you for so many of the things that are in here. It doesn't matter if it's domestic violence. It doesn't matter if you're drinking alcohol. You want a defense lawyer on your case, right? You want somebody who's good, somebody who's experienced. I've been practicing criminal defense now for almost 30 years. I've done countless first-degree murder trials and different types of serious cases and different types of gun cases, state courts, federal courts. We've done appellate court cases in state courts and federal courts. We've done cases all across the nation in many different states. We have cases right now in many different states. If you want us, you get us. If you want to let some other company choose, fine. You can use CCW Safe. They have the unqualified, absolute right to decide who your attorney is. Sure, you have a right to suggest. If that's what you're looking for, check out CCW Safe. You want to know who your lawyer is? You want to have a lawyer you're talking to immediately? You want to have attorney-client privilege? You don't want to have all these exclusions? Sign up in the Attorneys on Retainer program. Check out our program. It's online. Go to attorneysforfreedom.com. Look up at the top right. You'll see a red button. It says Attorneys on Retainer. Click that button. There's lots of information there. Our contract, or fee agreement, as we lawyers call it, is right there for you to read. If you have questions about it, call the law firm. You can talk to us. You can email me directly. It's Marc, M-A-R-C, at attorneysforfreedom.com. Just a reminder, the Attorneys on Retainer program is now a national plan. That's right, wherever you live in any of the 50 states, including Washington, D.C., you can sign up in the Attorneys on Retainer program. How do you do this? How can we still defend you in your state if we're not admitted in your state? Okay, well, there's a rule called pro hoc vice. You got a Sixth Amendment right to decide who you want to defend you. Now, it's not an unlimited right. You got to have a licensed attorney. They got to be in good standing. So there are different rules in each state for pro hoc vice. The way it works is we hire a local attorney in your state. That is the person who makes the motion to have us admitted pro hoc vice for the purpose of one case, so we can represent you in your state. We've done this on many occasions, never been denied. Don't expect we'll ever have a problem with this. This is how we can represent you in your state. If you get charged with a crime and you say, hey, I acted in self-defense, and you want to know who your lawyer is and you want the Attorneys on Retainer, our team of lawyers, to get involved and defend you, easy. Sign up in Attorneys on Retainer program. Any of the 50 states, no problem. All right, so those are my thoughts on the CCW Safe program. Make up your mind for yourself. There's lots of other things that CCW Safe provides that Attorneys on Retainer doesn't provide. To be fair, there are many other things. Figure out what's right for you. I would suggest that the reason you're signing up for this, I know why you're signing up for this. I've been speaking at gun shows for over 20 years. You're worried you're going to pull out your firearm and get charged with a crime, and you want a good lawyer backing you. If you want to be a member or a client of our firm, a member of our program, you are actually a client of our firm, check out Attorneys on Retainer. Peace.